Welcome to Aging Insight with your host, John Ross and Lisa Schollmeyer. This program is made possible by
Welcome to another edition of Aging Insight. I'm your host, John Ross, here with my co-host, Lisa Schollmeyer, and we are elder law attorneys right here in your neighborhood. And we come on this program every week so that we can give you the kind of information that we know you need to age on your own terms, to avoid things like institutionalized care, to avoid becoming a burden on your friends and family, and ultimately to avoid going broke in the process. And we know that there's lots of tools that you can use to do that, and there's lots of ways, and there's lots of information out there, but we know that you've got to have that information. It's no good if the information's just out there where you can't reach it. So that's why we come on this show as a way to deliver that information to you. That's what this program is all about. Well, today we're going to be talking about something that's pretty popular out there. You know, you probably would have a hard time finding something that Ted Kennedy, financial guru Susie Orman, Steve Jobs, the founder of Apple, and Paul Walker, the guy from the Fast and Furious movies.
The actor, okay.
What do all of these folks have in common? Well,
and Robin Williams too.
And Robin Williams, yeah. In fact, a lot of people, and not just these famous celebrities, but your next door neighbors and things like that. The one thing that all of these people have in common is that they use something called a revocable living trust as their primary estate planning tool in lieu of a will. So,
well, you know, that's
what
right.
is all of that business?
Well, you know, John, a lot of times when a famous person or celebrity dies, you know, there can be tabloids about, you know, what they do with their estate plan, who did they leave their property to. And, you know, if someone has done a last will, you know, I, Lisa Schollmeyer, being of sound mind and body, you know, hereby make the following dispositions of my estate upon my death. And then this document just simply gives a laundry list of who you want different property to go to and what property that is. Well, you know, it doesn't take a tabloid, you know, a family being exposed on a tabloid to see that, hey, you know, maybe you don't want the whole world to know about what your plans are for your assets and for your family at your death. And so this tool of using a trust instead of a last will and testament has really become a more popular way to pass those assets at your death. And one of the primary reasons of that popularity is a trust that passes property is private. So nobody else in the whole world other than your trustee and the beneficiaries of your trust know how that property was passed at your death. So, you know, privacy is obviously a big concern for celebrities and famous people, but you know, it's still a concern for us common people too. So
Sure. And you know, just as some background, you know, a lot of times when you say the word trust, people will think about, well, oh yeah, well, I've heard about that. You know, that's what these rich celebrities use, and I'm sure there's a bunch of, you know, if I had a whole bunch of millions of dollars, well, then maybe I'd consider something like that too. Well, let's start with the basics. What are the fundamental pieces of a trust? Well, every trust, no matter which one, whether it's the person down the street from you or Robin Williams, all trusts have three things in common. They have the person who creates it, that's called the grantor. They have the person who's in charge of it, and that's called the trustee. And then you have the person that receives the benefit of it, and that's, of course, called the beneficiary. With the most common revocable living trust, the same person is all three of those. So I am creating a trust, I am in charge of the trust, and I am the beneficiary of the trust.
Right.
In other words, it's my stuff, and I can do whatever I want with it.
Right. So, the idea there is, people don't want to lose control of their assets, and this is a vehicle which you can use to plan your estate, but also remain in control of your assets and benefit from your own assets while you're living, just like you would if you hadn't used something like a trust to hold those assets.
That's right. You can still bank where you want to bank. You can still invest where you want to invest. You can still own real estate and buy and sell all of those. Nothing really changes about your life other than the name. And so instead of something being, say, in John Ross's name, it would be in John Ross as trustee of the John Ross Trust. But as trustee, I can still pretty much do whatever I want. But here's something. What if I become incapacitated and I can no longer manage my own affairs? Well, if I have named a successor trustee, which I would have in this document, then that person is able to immediately step in and manage all of my assets on my behalf without having to get appointed as my legal guardian over my finances, without having to file accountings and inventories with the court. They're able to just immediately step in. So, Lisa, oftentimes people can use a revocable trust as a tool to avoid the necessity of guardianship, at least over their financial assets, to keep that out of the court system while they're still alive.
Well, and that accomplishes that same goal of keeping everything private.
Absolutely.
Like you said, no accountings and whatnots with the court. And, frankly, if you become incapacitated, you will have to have thought in advance of who you would want to manage your property. And so in this case, you're naming a successor trustee who could manage that property. And you've already selected that person, so it's not up to a court or other family members to fight out who's going to be in charge of your finances and your property. So a trust for use and planning for incapacity is a great way to use a trust. And of course, the other facet of using a trust is planning for death and how to pass assets at that time. So, what we're going to do is we're going to take a break and we're going to talk about, some of these other facets of the trust and when we come right back, so stick with us.
Off of McKnight Road in Texarkana, Texas, the Oaks Independent are apartments for seniors who love secure peace of mind and consistency in their lives. You're going to fall in love with this newly built luxurious residential establishment for the aging adult. All bills are included and all apartments are wheelchair accessible, inclusive with all the amenities. Live in style, comfort, and accessibility. Live independent. Call today to schedule a tour. The Oaks Independent.
With my dad, it was in a hospital setting, and in his situation, he fell into renal failure. He also helped us make the decision to be on hospice. I have to admit, it took a huge weight off our shoulders for him to be willing. That offered us a lot of comfort, along with the hospice company itself, but it gave us closure. And it helped us through the entire process.
SEMA Hospice, comfort and care when it matters most.
Hi there, I'm Larry Sims. It's been my privilege for the past several years to be a volunteer board member of Hospice of Texarkana. And there I'm able to represent community members like you. We continually customize our end-of-life care to better meet the needs of our community. As an example, our medical director and nurse practitioner still make visits to homes and facilities. Call today to learn more about the help we can give your family. Hospice of Texarkana, the nonprofit hospice established in 1985 for the community, by the community.
Welcome back to Aging Insight, everybody. I'm your host, John Ross, here with Lisa Schulmeyer, and today we're talking about an estate planning tool that is really blooming in popularity, in large part because of some very favorable articles in magazines like Forbes and AARP, but also because of the use by a number of celebrities, and not just here recently, but over time, but this revocable living trust as a tool, as a way to plan your estate both while you're alive and also at death. And so we started out by talking about the fact that what you're doing is you're creating a trust, which is, it's really just a stack of paper.
Yeah.
But once you've signed this, you've created this kind of legal entity.
Yeah, it's kind of like, you know, if you were in a business and you created a corporation. I mean, you sign a stack of papers and now you have a corporation. So
right, and so it's
works
very
the same
it's
way.
very similar. And like that corporation, you know, if you're the president, the CEO, and you own all of the stock, then you get to do whatever you want with that corporation. And the same thing goes with a trust. If you're the person who creates it, the grantor, and the trustee, and the beneficiary, then it's your stuff. But because you have named successor trustees, if you get incapacitated, somebody else can immediately step in. And so then the next kind of thing is we start talking about, well, what happens with this trust at death? And this is another big advantage to using a trust. You know, we've talked in the past about probate transfers and non-probate transfers.
Yeah, so you know those non-probate transfers are transfers of your property that happen outside of a last will, such as if you have a pay on death on your CD at the bank, that would be a non-probate transfer. That's where you've named perhaps a child to receive that CD upon your death. You filled out that paperwork at the bank. You know, that particular CD will never pass through the terms of your last will. And so here, with using a trust, essentially any property that we place in the name of the trust, at your death, that property will pass in outside of probate, which means without any of the court proceedings that go along with the probate process, you know, and so it happens a lot quicker, and it also keeps the property that passes in this manner, it keeps that property away from your creditors. So there's a couple of good things right there. It keeps it out of the legal system and away from creditors.
Right, so that can be really a valuable tool in all of that. And again, it happens according to the terms of the trust. So whatever the terms of that trust are, that's how your property is going to pass. Now, I've had lots of people, and I'll mention this, and they'll say, well, John, you know, me and my husband, we've just got the one kid, and so why would anybody ever have to probate a will for us anyway? I mean, when we both die, everything goes to our son, right? Well, yeah, that's probably right. You know, under both Texas and Arkansas law, if both spouses are deceased, everything's going to pass to their child. The problem is chain of title. You know, that home that you own, that home is sitting there in your name, but you're not there anymore. And maybe that child wants to sell the home. Well, the buyer wants to make sure that the person who they're buying it from is buying it from the right person. And they want your signature. And of course, your son or whoever it is saying, well, I'm sorry, but mom's dead. She can't sign, but I'm an only child, so I'll sign. Well, a smart buyer, or more importantly, a smart title company, is going to say, well, how do we know you're the only child? How do we know that you're the rightful heir in all of this? And that's where you end up having to go through the probate process, is in order to clear the chain of title so that it's clear who is the rightful owner and therefore who is the rightful seller. If you have the property in a trust, then it's going to pass according to the terms of the trust. So if that trust says that upon your death, everything goes to your son, then that's what happens. Now, you might be saying, well, but John, you know, I've already got my kids named as the beneficiaries on my CD at the bank and on my life insurance policy. Well, let's say that you've got the 3 kids named on that CD at the bank. And upon your death, that would transfer automatically to those 3 kids. But what if one of them has died before you? Or what if you're in a car wreck with one of them and you both die? And so you die at the same time. What happens to the deceased person's share of that? Does it go to their other siblings? Does it go to their children? Does it go to their spouse? What you may not realize is that that bank card that you signed where you named them on there, buried in all of that says what happens. And that may or may not be what you wanted. Whereas if that CD was in the trust, you would have spelled out in that trust who gets what and what happens to the share of a beneficiary who predeceases you. So you can really cover a lot of different contingencies in all of this.
Well, and the other great thing really about a trust is, you sign that stack of paper and you can form the trust, but you can amend it at any time. And it's very simple to amend. So there's no additional paperwork or tax returns or anything like that at this point dealing with that trust. So once you get a trust in place, you get some peace of mind for how your property is going to be managed if you become disabled, and what's going to happen to your property at your death, because you have already put it down on paper and directed it to happen. And all of that occurs, again, outside of the court system, outside of the probate process. Many times, like you were saying a moment ago, John, people think their family situations are simple and they won't have to take that will and go in front of a judge, but those instances are becoming fewer and farther between. It's rare these days to have a situation where we don't have to do any sort of probate at all, and so you can really avoid that by using the trust.
Yeah, so it is a powerful tool, and again, you're not giving up control of your own assets, and you're not setting anything in stone. As Lisa said, you can amend any of the provisions of a trust or revoke it entirely, and actually amending a trust is simpler than amending a will.
Yes.
When you change a will, the change has to be executed with the same formalities that the original will was required to have. So, when you think about it having two witnesses and a self-proving affidavit that's notarized, all of that has to be done for any change related to that will. The same requirements don't apply to amending or changing a trust. It can be quite simple to make those changes over time, which again gives you quite a bit of flexibility. But now we may be sounding like there's just absolutely nothing bad about a trust. Well, there's pros and cons to everything. So I think what we'll do is we'll take a quick little break. We'll come back and we'll talk about some of the other factors to consider when trying to decide whether or not something like a revocable trust is appropriate for you. So stick around, we'll be right back.
All our moments should be cherished. SEMA Hospice provides comfort care when you need it most with compassion, dignity, and respect. Along with Jordan Health Services, SEMA Hospice provides compassionate continuity of care. SEMA Hospice, comfort and care when it matters most.
As things get older, they require more care. This car and I have seen a lot of miles together, but because I take care of her, she runs just like she did in 1955. That's why I chose the Wadley Senior Clinic, with an individualized care plan designed just for me and a convenient location off Jefferson Avenue. They have everything to keep me running like new. It's not about the miles, it's about the journey. Let the Wadley Senior Clinic keep you happy, healthy, and cruising down the road of life.
Hi there, I'm Larry Sims. It's been my privilege for the past several years to be a volunteer board member of Hospice of Texarkana, and there I'm able to represent community members like you. We continually customize our end-of-life care to better meet the needs of our community. As an example, our medical director and nurse practitioner still make visits to homes and facilities. Call today to learn more about the help we can give your family. Hospice of Texarkana, the nonprofit hospice established in 1985 for the community, by the community.
From our first moments to our final days, life's journey should be remembered free of burden and worry. Families should be cherished. SEMA Hospice provides comfort care, dignity, and respect. Learn more about SEMA Hospice at semahospice.com. SEMA Hospice, comfort and care when it matters most.
Welcome back to Aging Insight. I'm Lisa Scholmeyer, and I'm here with John Ross. And John and I are elder law attorneys based here in the Arklatex. You know, Aging Insight is an information program so that you can get the information and then decide if it applies to your situation. You know, today we're talking about an estate planning and life planning tool, maybe a property planning tool if you want to think about it that way, called a revocable living trust. You know, and so we've talked about in earlier segments how a trust is just a stack of paper that you sign that creates this legal person called a trust, and the only job a trust has is to hold on to your assets for you, and you're in control of those assets because you're in control of the trust, and you can get those assets anytime you like. You can spend them however you like. You can give them away if you would like. You know, it's a very flexible tool, but yet if you become disabled or at your death, then the trust passes the control of those assets to your successor trustee, who then, in the case of your disability, can use those assets to keep providing for your needs. And then in the case of your death, the trustee can then disperse those assets, you know, per your instructions that you've included in the trust. You know, we've talked about a trust is private, and a trust, any assets in a trust, avoid the probate process. Now, before the break, John, you said, hey, so far it sounds just, you know, like cotton candy and marshmallows, just the most perfect thing there is. But there are some considerations.
Sure. You know, one of the things is the initial setup of all of this. You know, if you think about it, if a meteor came crashing through your living room right now, and you were deceased, somebody would have to go around to your various banks, collect your life insurance proceeds, retitle your house to your heirs. There would be a process of changing everything over. Well, you know, when you do your estate planning by virtue of a will, typically you're going to end up doing all of that under court supervision after the person has died. So in other words, you won't be doing any of it. Somebody else will. The people that you leave behind, they will be doing all of that. With the trust, you're doing the work now. You're going from bank to bank and making sure the assets are titled correctly, that your life insurance beneficiary is named correctly, that it goes to the trust as opposed to the people you have named, that your real estate has been deeded so that it is in the name of the trust. So there's all of the kind of things that you would have to do following somebody's death. Instead of putting that off on somebody else, you're having to do all of the work ahead of time. So the first issue with all of this is the fact that, you know, you've got to do all the work yourself. You got to get around. Now, of course, if you've got a good advisor, elder law attorney, they're going to help you with all of that. But there is still quite a bit of work to do. The other thing is, as time goes on, and you sell property, buy new property, you got to keep up with it.
That's right. You know, if you sell your home that you had previously deeded into your trust, and you purchase a new home, well, when you purchase that new home, you would want to make sure that the title owner on that new home is the trust. You know, and that's the biggest mistake we see people make when they create a trust. They really like the idea of the trust being that management tool, but then they forget to put anything inside the trust to manage.
Right, and so you end up with an empty box.
Right, empty box, and that's not helpful. I guess it helped the lawyer that drafted the trust,
I guess.
but it doesn't help you. So probably the biggest mistake we see is that people fail to fund their trust initially, or they fail to keep up with it as they buy or sell assets. And you know, it's not hard. You don't need an attorney's assistance to put new assets into the trust. You know, like in the example, you purchase another home.
Sure.
You know, just let the title company know how that title, that deed has to read, and it's taken care of.
That's right. So you are trading, doing some work to get it all set up, and keeping an eye on it as you go. But really, most of that shouldn't be. First of all, it's certainly not any different than the kind of work somebody would have to do after your death had you not done any of that. And in addition to that, it really shouldn't be any different than you managing your own affairs. You can still buy and sell and get loans and do everything else just like you could do. So the revocable trust is it's a very powerful tool. Now, of course, a lot of people, Lisa, will ask me, they'll say, well, John, what's the minimum amount of assets I've got to have in order to use a trust?
Well, what I always tell people is that it's a management tool. It's not a wealth sheltering tool necessarily. It's just a way to manage what assets you do have.
That's right.
So there's
So if whatever you have is important to you, and you want to make sure that it's managed for your benefit in the event of your incapacity, that it passes smoothly and easily to your heirs upon your death, and you want to do all of that in a form that is private and avoids court involvement, then really the amount of assets you have is irrelevant. Now, of course, if you've got a whole bunch, there's some tax provisions and stuff, but don't let that intimidate you away from it. It is a very valuable tool that should be explored. It may not be right for everybody, but it ought to be explored as a potential option for many people.
Well, that's right. And what a lot of my folks love about using a trust like this is, they feel very certain that the way they've arranged their trust, that it's concrete and it's going to happen exactly as they have arranged it, as opposed to a probate process where between creditors and politics, and lawyers.
Who knows where the end is?
That's right.
That's right. Well, if you have any more questions about any of this, of course, you can always catch us every Saturday at noon on 107.1 during our live call-in radio show. You can also reach us on the internet at www.aginginsight.com, where you can catch episodes of the show and podcasts of the radio show. So tune into all of those, and of course, tune in next week for another edition of Aging Insight.
All right, bye-bye.
Bye-bye.
Thank you for joining us for this week's Aging Insight program with John Ross and Lisa Scholmeyer. This program is made possible by